All right. Good morning, everybody. I did get the pop-up notice that the webinar has started, so let's begin. Welcome to WILMIC's Summer CLE Half-Day Program. This is one of two 3-hour programs that WILMIC offers free to policyholders. Thank you for joining us before this long Labor Day weekend. Happy to have you with us. We have two presentations this morning. The first presentation is titled The Rising Tide of Estate Planning Claims and Related Ethical Concerns. The second, that will run from approximately now until about 10:15 or so. Then we'll take a short break and we'll run a second program from 10:30 to 11:45 or so. The second program is titled Deep Breaths Won't Get Me Out of This, and Tom Watson's presentation, which is life and lawyering. And so we'll get into some ethics concerns related to maintaining your well-being as a lawyer. And we're happy to have with us Courtney Risk Easterling from Dahlia Consulting to offer her insights. She is, for a long time, she was part of one of our sister companies in Kentucky and was a claims attorney and risk management consultant. So we're happy to have her with us. I am Matt Beier. I am WILMIC's Senior Vice President, and I'm delighted to have with me for the first presentation, WILMIC's Director of Claims, Brian Anderson. You know him, you love him, and hopefully, if you need to, you can call him and he can help navigate anything that you need. And we also have Attorney Bill Williams, a shareholder at Belmore and Richter. And I'm just going to give him the blanket title of estate planning wizard. We turn to Bill often to find some answers to some of those finer points of estate planning when it comes to handling claims. So why don't we jump right in? And just as a sort of broad overview, what I'd like to do is go over some of the basic elements of legal malpractice. We'll talk about why we're talking about this topic, estate planning, so much, and it has to do with our recent claims experience as well as nationwide claims experiences related to estate planning practices. We will have some what I think is good news, but I'm sure Bill will set me straight that it's not all good news. There's more in there as far as case law developments. And then we'll, of course, weave into this entire conversation ethics, rules, guides, tips about how to satisfy your obligations under the rules of professional responsibility, and also how what a good practice is to avoid any claims. So follow along with me. Brian.
Yeah, I lost, to answer the question that everyone's asking, I lost a bet and I had to put Matt Beier on my screen, Brian Anderson.
Yeah, I was just hoping that you were going to say all smart things today, Brian. So that's why I wanted it to be Matt Beier, so I get credit for it. But no, yes, we had a link issue, and Brian is showing as Matt Beier, but indeed he is Brian Anderson, the one and only. Well, one of many, I guess. But in any event, I have the outline up. I'm sharing the screen. If you have any questions along the way or comments along the way, please go ahead and use the question and answer button in your Zoom software and get those to us, and we'll do our best to answer those. So first question, will you ever have a malpractice claim? We, in the past, we would usually cite an ABA statistics that shows that 1 in 3 lawyers will, in their career, experience some kind of claim. More recently, Ames and Goff issued this study in May of 22, and it specifically zeroed in on a couple of different practice areas, one of which is the one that we're talking about today, and that's estate planning, where those practitioners do face a higher frequency of claims. Typically, we do run a top 5 list, and estate planning, trust, probate, and estate, as we call it, is one of those categories that does produce a high number of claims. It's also right up there in the top 5 as far as severity goes. And so for those of you who don't know, that's just how we refer to when the claims come in, how many are there, and how much money do we pay out for each claim. So being in the top 5 in both of those categories is not meant to scare you. It's just meant, I think it's more of a reflection of how many people actually practice in estate planning. it's well over half. In fact, I think it's over 60% of our policyholders do identify estate planning as one of their practice areas. So a lot of people do it, and there are a lot of issues that come up in the course of that practice. So it's really not a big surprise that it is one of those areas that demonstrates a higher risk. So do you think you've ever committed malpractice? You might not know how close you came. Oftentimes, and I think this is true in an estate planning practice, a client is worked for, the file is opened, and it's relatively easy to close and put in a box and put it up on the shelf. And if nothing goes wrong, well, then great. But it is something that we do need to talk about in the context of when an error might be discovered. And that's important because of the statute of limitations as it's applied to legal malpractice claims. In 2018, I believe it was, the statute of limitations in 893.53 was shortened from 6 years to 3 years. However, around that same time, Bleecker v. Cahill was decided. And you can read the brief summary of that case, but ultimately what happened was that when legal malpractice was alleged in that real estate matter, that 3-year clock didn't start ticking until the claimant discovered the error. And that had to do with a provision in his lease that did not allow for the full payment as he contemplated it and as the parties contemplated it. And when the other party happened to be Aurora, I believe, Aurora Healthcare, backed out of the lease, the developer was left with only half of the payments having been made over the course of the term of the lease. So in any event, he discovered that in 2013. And so rather than starting in 2003, it was really the 6-year statute of limitations, which applied at that time, plus 10 years. And that does happen indeed with estate planning matters. And so it breathes a little more life and a little bit longer life into claims that are in this practice area. So that you may not know whether you have committed malpractice, but it can be something that's discovered and brought to your attention later. The elements of legal malpractice, the first is there a lawyer-client relationship? And we'll talk about how Rule 1.4 in communication weighs in on whether or not a lawyer-client relationship is established. There's also a Rule 1.3, which does suggest or require that any doubt about the lawyer-client relationship needs to be cleared up by the attorney. It puts the responsibility on the attorney, not necessarily the client or potential client, to clear up whether that attorney-client relationship actually exists. The negligence, the rest is, torts 101, duty, breach, causation, and damages. And be aware that the duty owed to the client is that which a reasonable attorney would owe to any client. And be aware if you are holding yourself out as a specialist in estate planning, that does raise the duty owed to the client. And I'll let Brian speak more specifically about what actually happens to that duty. But essentially, it raises the expectation to what another expert would do, another expert attorney would do for a particular client in the same or similar situation. And then proximate cause and damages. We often talk about something, a concept of a suit within a suit. Your case doesn't get better just because a lawyer made a mistake. You still have to prove that you would have been successful or that you did have, in fact, some loss as a result of the mistake that was committed by the attorney. And if your case underneath the legal malpractice claim stunk, it's not going to get better just because the lawyer made that mistake. It's not an automatic win. You still have to prove that it caused some kind of damage, and you have to prove the damage. Brian, maybe you could jump in here and talk about who, in fact, is making the mistake, and then maybe give a little, a couple of comments on what we talk about in the context of dabbling and then what that means.
Sure, and Matt touched on why we're doing the estate planning again, and just to jump ahead for a second, Matt, you should pull up page 4, is it? 5.
You got it.
5 for Yeah, go one more, man. I think, yeah, I just want to kind of start here because this is the fresh data from so far through July. And what's alarming is that 46% of all the indemnity dollars WILMIC is paying on claims is in this one area of law. And I think we track 36 areas of law. So to have a state probate trust at 46% of the severity, I guess that answers the question, why are we doing a program on estate planning? It's costing us and you all a lot of money. And secondly, it's the second highest area of claims in frequency. But maybe more importantly is how expensive these kind of claims are. And we'll talk about that a little bit. I'd like to get Bill's thoughts, but a couple of thoughts come to mind as to why that is. I think the size of the estates are quite large now. I mean, that's one. Two, litigation costs are that's one of the problems of the claims in this area is the claim that, well, you put me in a position where I had to litigate because there was an ambiguity in some document, or you didn't do something that I wanted you to do. And then they look to the attorney who allegedly made the error for all of the litigation costs. And those can be six figures easily or higher on the fees alone. So that's, I think, explaining some of the severity. And then the other point I wanted to make is this: when Matt put up those elements, Matt, back to the number two, when you have I've been around WILMIC for a long time, and I can tell you that there are a lot of examples of cases where a lawyer has a relationship with a client and may have made an error, but the client says, you know what, you're my lawyer, you've done a good job for me, I'm not going to make a claim against you. I mean, I'm not trying to advocate that's a good way to practice, but that's the reality. But in this area, when there's a disinherited beneficiary who doesn't know the lawyer, never met the lawyer, and says, you know what, I don't know who the lawyer is, but somehow I didn't get what I was supposed to get out of this estate, out of mom and dad's estate, whatever the situation is, they're more inclined to bring a claim, in my opinion, because they don't care or have any feelings towards that lawyer at all, don't even know that lawyer. So that's where this opens up the door to claims in this area, because they don't have any sympathy, relationship, or otherwise with that lawyer that a lawyer client in the traditional sense might have, that might be able to work with that lawyer to avoid a claim. So those are just some background thoughts. Bill, I guess now that I've stated that and threw you out there, but what are you seeing in terms of size of estates? Am I in the right ballpark in that regard?
Absolutely. And an important thing here is that the size of the estate doesn't really necessarily dictate complexity. And you can be dealing with a very simple thing, just a drafting error. And, if it's a small estate, it's a small number. But if it's a multi-million-dollar estate, the mistake is magnified by the size of the estate. I should also point out that we're right now kind of living in a period of grace where many, and I think given the people who are insured by WILMIC, we tend to work on the smaller side of estates. So estate tax, the federal estate tax, has been off the radar, but that may change. And when you talk about estate tax liability of 50% of the estate, those claims can be very large very quickly. And, I'm afraid that that 46% number could get worse if there's a significant change where there are more estates subject to the estate tax, which inevitably leads to more malpractice claims, because managing estate taxes is complex. And if you mess it up a little bit, you've messed it up completely. And the liability is severe.
One other quick point on the four elements that we just had a trial that concluded last evening in our policyholders' favor. This is just as a general comment, but proximate cause and damages are not as easy to establish as one might think. And so it just goes back to our general theory or theme that we try to impress upon policyholders. If you do make a mistake, please report and let's talk through it, because the lawyer has a tendency to fall on his sword and want to just to say, I'm responsible for everything. Proving up cause and damages is often much harder than one might think. And that's why, yes, you can feel bad. You may have made a mistake, all that. But in the end, did you put the client in a worse position than they would have been, or in a different position than they would have been, but for your negligence? That's not so easy to establish. And when you think through it, sometimes I think you'll realize that that's the case. But that's why you need good counsel to address the situation, even when the initial conversation with the client about what happened happens, so that you don't say things that you regret down the road, not thinking through the elements.
Yeah, Brian, if I can elaborate on that a little bit, it is, I think estate planners are particularly by our nature prone to assuming they're responsible for everything related to a plan, even when it doesn't go so well. And often our experience has been that people will say, well, it was obviously my fault since it's my estate plan. But when they report back to us timely and we look at it, that's often not the case. And you didn't do anything wrong or anything that's legally vulnerable, I would say. So that fall on the sword reflex is particularly strong in estate planners. And you need to pull back. And it's a good idea to let somebody else take a look, because I think Brian can concur with this. Often as not, we find that's not really the case. And there was nothing wrong done that was causal, and or it's certainly defensible. So going back to the client and saying, it's all my fault, how much money do you want, is not the right response.
Yeah, and the other point, Bill, in the estate planning, there are situations where no matter what you did, there was going to be a fight in the estate due to family dynamics that you had nothing to do with, and no way could you ever overcome. So
that's right.
So it's just the lawyer becomes an easy target, but the family problems are not yours that were created. But I guess the point on that, all that, is make sure the record's clear about, and we'll get into some of this, Matt. I know we're jumping around, but who the client is, what the assignment was, the things you discussed. To have that in writing is so important and if there's a claim, or even a frivolous claim, but just to defend your interest as to what was discussed and why you did what you did, and that the client was understanding of that and wanted to go in that direction.
All great points, you guys. We do have a question, and I like to answer these as they come in, and I think this one is certainly relevant. But the question is, are you seeing claims in the area of medical assistance eligibility planning?
Yes. And that's a good segue, Matt, to your dabbling comment. That is another can of worms in terms of compliance with or understanding some very complex.
Go ahead.
What's that? Oh, just that's just because you're maybe an estate planning attorney doesn't necessarily mean you're an expert on Medicare compliance, that type of divestments, et cetera. So that might be a good opportunity to consult with someone, or maybe that's not an area you want to just delve into if you're not experienced therein.
Sure, and that's the point about dabbling, and I think that's that brings in Supreme Court Rule 20:1.1. Lawyers shall provide competent representation to a client. That requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And the comment there, WILMIC is not here to say don't do anything new, stay in your lane only, and never diverge. That's not the point. But the point is to bone up on the law, stay current, and go to programs like this one, where you hear from folks like Bill Williams, who they're on the front line. They're actually engaged in a lot of these issues that come before the courts and get decided by the courts, favorably or unfavorably. We need to know the law, right? But I also encourage, and this is something that we struggle with on the solo and small firm general practice board, is how do we bring value to that section of the state bar? And one of the ways that we can do that is to encourage networking. And so even if it's not just attending lectures or risk management programs like this, who do you know that you can consult about a particular situation, or medical assistance, or other issues that may arise that you may require some different expertise than your own to adequately serve the client. So dabbling is doing all of these things, venturing into new areas, new issues, et cetera, without having done your homework or without consulting your network. But certainly we want lawyers, and again, we'll talk more about this in lawyer well-being in the second half of the program. But it is important to feed your desires to venture into different areas or to take on something new. That's an important part of maintaining your well-being, staying interested in the practice of law. But make sure that you have established that you are providing competent representation to your clients.
Go ahead, Brian. Well, I was just going to say, when you get to the trial setting, which hopefully you won't ever get, but it's just fresh on my mind because that's where I've been the last few days. You're going to be up against an expert that knows that area of law better than you ever would have wanted to. But the point is, the fact that you're going to be up against an expert in that area of law. So if you're uncomfortable, take that seriously as far as, do I want to move forward? And don't just wing it, I guess is my point, because you will get crossed, especially like Bill brought up a tax situation. That gets to be fairly black and white. And if you're not a tax person and didn't understand or even appreciate what the ramifications were, it's not going to look good down the road. So these referral, I don't know, Bill, what do you think about, what do you do when you have a tax situation referral that the client doesn't really have any interest in pursuing? I mean, how do you protect yourself and your file when they may not be consulting with an expert that you're recommending?
Oh, this is right in the wheelhouse of the communication and transparency. You need to be able to show years later that you sent a communication to that client. And it can be email, and I like email because it creates a record that a phone call doesn't, unless you memorialize every phone call you ever have with a client that says, I pointed out that this plan may not be optimal for, this is just one example, for federal estate tax purposes. And you've decided to proceed nevertheless. But something like that can show that you raised the issue. You don't have to provide a tax perfect estate plan for a client if they don't want it. What you need to do is apprise them of the issue. And again, I'm harping on this because in 2025, we're all going to have to see what happens to the federal estate tax, but it could be that a significant number of estates, particularly in the dollar range that we work with, are going to have federal estate tax considerations. And boy, you better be ready, because if you don't circumscribe the scope of your representation, I will tell you that when you go to court, a judge who may have never written a will in their whole life will say, I don't see anything in this engagement letter that limits your representation. So you agreed to do this person's estate plan. You took on every aspect of it, including the tax. That's just what you can expect. So if you either don't want to address the estate tax issues, or you've talked about it and the client's decided, I'm not going to worry about it, I'm going to spend down before then, make sure you've documented it.
Yeah, and the client will often, which I observed the last couple of days, will say, well, my lawyer said he was going to take care of everything. I mean, that's the testimony. I assume my lawyer was going to take care of it. He told me, don't worry about it. I'll take care of everything. That's kind of the default answer that a client will say later down the road. So you definitely want writing that would say otherwise, not just your testimony, but written communication that says otherwise to contradict that type of testimony. The other one that came up repeatedly again, and I know, Bill, we've worked on cases where this has been a big issue, the billing statements. I just have to bring that up again because they're trying. It's interesting that the lawyer is getting faulted for not having sometimes more billing, they're trying to act like you spent this important case and you only spent 17 hours on the case. Well, the lawyer's testimony, well, I didn't write down all my time and I didn't put down every time you came into the office or this, that, and the other thing. So I think lawyers are trying to do their client a favor sometimes by not billing and not putting down every contact. And then when it comes down, the plaintiff's legal malpractice attorney is trying to make it look like the lawyer didn't spend enough time on the case. And I think lawyers are worried about overbilling. So you're in a real quandary, but I guess the only answer, I'm not worried about the billing per se. I am worried about the billing notes and dates and time spent. So please don't think you're doing a favor to yourself or your client by not putting down the date, what happened and how much time was spent, because that will only be used against you later.
I think that's right, Brian. And I think with billing, it is a form of communication. And when I started my career at Murphy Desmond, Bill Munt often told me that the bill is sometimes the only thing the client reads because they want to know why they're paying so much money for your service. So it is an important tool to weave into your communication exercise. And the description, even if you feel like you don't want to charge for it because it took too much time, or you just want to stay in the good graces of the client, still describe what you did. And even if you don't assign a particular number of hours or time to it, use it as a marketing tool and show that you actually did something. And then I often get bills, that will say no charge for the service described. And, I think clients will appreciate that. At least that would be my inclination. But it is still a very important form of communication. And I want to back up, Bill. You started to delve into engagement letters, and anything that costs over $1,000, it's got to be something that's represented to the client in writing. That's Supreme Court Rule 20:1.5b. And then we do have some in the materials. We have some points about what should be included in your engagement letter. Bill, do we have enough in here for the engagement letter? We've got 5. One, obviously identify your client, and there's a whole lot that's underneath that. As far as identifying conflicts of interest or other things that might have an impact, it's important to clearly identify your client. The scope of your representation, certainly an engagement letter would be looked to identify what you're supposed to do, what you're not supposed to do, the terms of your representation, what you're going to charge, and then any actual conflicts of interest need to be disclosed and give the client the opportunity to consent to your continued representation. What else should be in there? Is this a good starting point? What comments do you have, Bill, about how best to draft an excellent engagement letter?
My thoughts on this today are based on, I found myself falling into the habit, not a good one, of talking to a client, clearing conflicts, and then sending my assistant an email saying, send our engagement letter to X. And the canned letter goes out. And each engagement letter really needs to be individually tailored to your representation. I mean, you're going to have a template, but if you've already talked to the client, you've already learned some things, you need to incorporate that into the letter. And you need to do this every time. We don't like to do it because it's one of these things you don't like to charge for, and it seems like busy work, but it is so important on the back end, particularly if things don't go well, that letter not look like a canned thing that doesn't really fit the facts. For example, if you've talked to them and they've already indicated that they don't want particular services, that has to go into the letter. That scope of representation definition is critical. And for those of us who are going to be helping to defend you if something goes awry, and again, as Brian pointed out, you'll be dealing with people who may have never met you and don't care about you at all, even though the matter relates to a client you really liked and worked with. Define the scope of representation carefully. And of course, every time you're representing spouses or someone where you've got a pre-existing relationship with one client and their partner also needs their estate planning done, you need to point out the conflicts of interest that are inherent in estate planning when you're dealing with couples and get the client's consent to that representation. It's a waivable is not exactly the right word, but it's a conflict that clients can consent to, but it has to be in writing and it has to be disclosed to them. So that's critical, and that needs to be individualized.
Okay, we have a couple of questions. I think these are appropriate to address now. For flat fee billing, should you be keeping records of the amount of time allocated to an engagement? And Brian, I'll look to you for this after I make a quick comment. When I was in law school, I worked with a guy named Nick Bocus, and he kept a log. It's just a binder, just something, but he did it for every case. And it wasn't, obviously he didn't have the fee or the typical billing to worry about, but it was just a running log of what he did every day. If he opened up that file, he made a log entry. So I think this is kind of the same idea. So if it's a flat fee billing situation, maybe the client only sees one bill, and that's the total amount to be paid in the flat fee. But again, in the interest of satisfying your obligations under Rule 1.4, you should still be communicating with the client what you're doing, and keeping records of the amount of time dedicated to any engagement, I think, is a terrific idea. And so I would definitely encourage that. Brian or Bill, do you guys have any thoughts on that?
No, I agree. I mean, it's a pain in the neck, and if you know you're never going to have a grievance or a claim, then you don't have to write anything down and don't have to worry about it. But you don't know when those come is the problem. So if you have a fee dispute, a grievance, a claim, any of those issues, you're going to be so glad that you took the time. And I know it takes a little time, but to note exactly what Matt said, only because I know my memory isn't as good as it used to be. In fact, well, I'm assuming it used to be good, but you just won't remember it, because for you have a lot of things going on, a lot of clients. That client, you're the attorney that's handling their case, so they remember, at least think they remember everything, or that they don't remember when you contacted them. Either way, but you're going to need a log to at least work off of to answer to a fee dispute or a grievance or a claim. So take the time to do it. Hopefully you never have to use it, but you're going to be so glad you did if and when a problem arises.
Yeah, I think that's right. And sorry, Bill, go ahead.
I mean, you can take this from real life. If you're being deposed, you will be asked, so how much time did you spend working on this estate planning matter? And if you say, oh, I don't know, it was too long ago, I'm really not sure, that's not an answer that we'd like. If you can say, I've looked at my records and we spent, 12 hours on this estate plan, that's a much better answer. There are also two considerations. It's one, what are you doing for your internal record keeping? And what do you show the client? And if you choose to do a one-line bill for flat fee work, that's a choice. But, as we've discussed today, more information is always better. And if you provide a detailed explanation of everything you did, and at the end there's a single dollar amount, that is a much more impressive, pleasing bill, or at least will make the client feel like they got value for their dollar than, estate planning $2,000 kind of thing.
Yeah, just to further that, the trial that was going on this week, they were talking about a transaction that occurred 6 years ago, or over 6 years ago. That, I mean, I don't even want to try to think back what I was doing or where I was 6 years ago. But I mean, you're just not, without a record, you're not going to honestly remember. I don't think as the attorney. So you need that information to be able to not just go up there and say, I have no idea. And the client will have these specific memories of exactly what happened. This is the problem. So you want to make sure you have something to counter that.
Yeah, that's right. And the next question in the queue is it okay to have the entry not billed to the client at all, but still in internal timekeeping records? Does that still help? And I think Bill just answered that. When you are deposed, you have to have something that will refresh your recollection about what was done, or at least offer a description of what was done. And the one line bill, and that's the only reflection of all the work that you did, at least as far as billing goes, is a worse position to be in than if you actually have those internal timekeeping records. However you do it, I would suggest developing habits, so that you do it the same for every file, and it's the establishment and the practice of a good billing procedure. I think that's going to be helpful no matter how you charge your client, just to be able to describe your work and what you did on the file, if you need to. Okay.
I don't know if this is the right time to cover, but I just wanted to. I brought up the fact that you might get a claim from someone you didn't meet, a disinherited beneficiary that lives in Arizona, that type of thing. But Bill, the other cautionary thing that we see that I want you to just offer to the audience is this: where is it mom or is it daughter that's running the show? This is the opposite situation I described, where mom always comes in with the daughter's getting the house. There are four other kids that are going to get virtually nothing. What kind of protection? That's the other common claim we see is undue influence. Who was the client? You let daughter run the show. Maybe daughter helped pay the bill. Well, how can a lawyer protect themselves about the claim from the other 3-4 children that are going to claim bad sister ran the show?
This is a critical point, and one thing where our practice area may differ from typical litigation is that it's not enough for the end result to be good. Let's take that undue influence example. Let's say someone makes an undue influence claim and the proponent of the will is successful in fighting that off. You go, oh, well, there's no problem there. That's not right. If that estate can show that you didn't orchestrate the estate planning process properly, and therefore there was a challenge that could have been avoidable had you followed the standard of care, you are still liable. And that's where those 6-digit defense costs come in, even if there's not a cent paid to the person making the undue influence claim. So if you've got that situation, and we run into more and more of this as our clients age, mom is always accompanied by the child who, shocker, is going to be the primary beneficiary to the exclusion of the other 2 kids. You've got to watch that situation very carefully. You've got to be able to document, and I call it orchestration, and it isn't just a dog and pony show, but you have to set up the representation so that you are on one-on-one sessions with your client where you ask the question and look them in the eye and say, you realize you're disinheriting your other 2 children. Is that your intent, where the beneficiary is not there? And then you've got to memorialize that. We've dealt with this in situations where, if we could, we tried to set up an arrangement where we didn't even have that favored beneficiary driving the client to our office. We're meeting with the client at home alone, so that you can say, when it's challenged, yes, I met with the client. I felt she was competent, and I didn't have any indication that, she was being pressured into doing this. And the fact that she chose this beneficiary over the others was her, unencumbered intent. And that was my determination. You don't have to be absolutely right in some existential sense. You've just got to show that you followed good legal practice and you evaluated competency and undue influence while the estate planning process was going on, and you set things up so that your client always had an off ramp to say, well, she takes care of me and does everything. And I'm afraid if I don't name her in this will, she's going to stop taking care of me. I mean, then you got a problem that's a different problem. But hopefully they'll say, no, my other two kids aren't worth anything and I don't like them and I'd like to favor this other child. You document all that and you're going to be fine.
Yeah, and this is definitely a follow up to our discussion about communication. Communication is key. It really is sort of at the root of almost all, if not at least part of all of the claims that we see, where there's somehow obviously the client, when they actually file a claim, they're upset, or they're something went wrong. And usually, when communication is maintained and effective, there's less likely to be a claim. One of the things that I talk about is what I call an IAY letter. It's an I advised you, and this really just is on the heels of Bill's last comments. When something, not necessarily out of the ordinary, because I think there are plenty of testators and others out there, clients who do want to change their beneficiary designations. But what are you doing as the lawyer to make sure that they understand the consequences of what they're doing, including whether or not such action would invite litigation down the road? Oftentimes we try to write estate planning documents to avoid those kinds of things, so that there's some certainty to how what will happen upon the client's passing away. But the IAY letter is, okay, you talked about this change to your estate plan. If you do that, I advised you that this would happen. You chose to do it anyways. I think that's a very important letter. When we see those letters, when claims are reported to us and we ask for the pleadings and the correspondence files, when we see that letter in there, it's very effective at defeating some claims. So do be aware of that. Brian, any further words on how exactly to, or at least what we've seen as far as undue influence claims and how to avoid them if possible? I know that there is that disconnect between attorney and client when it's a disinherited beneficiary, but what else might be done?
I think Bill covered that pretty well in terms of the record that you want to establish to defeat that kind of claim. And your letter is important, Matt, but the other duty the attorney has is it's the client's decision. However, the attorney has to advise the client in the pros and cons of the decision they're making, so that they make an informed decision in terms of how they did this. And that comes up when I think the client does understand, but later feels pressure or something changes where this daughter is no longer so nice to mom, or whatever the situation might be. And then they come up with this thing where they say, well, I never understood that I wasn't going to be able to get my house back, or that most of my estate was just going to go to this daughter who now is not nice to me and is evicting me, or whatever the situation might be. So I think the other just piece of that is think through these scenarios. Yes, you say that as I advise you, but you have to make sure the client understands that this is a permanent decision. You are no longer going to have any interest in this home going forward. If things change, I'm just making up the TOD, or when the deed is transferred to a daughter kind of thing, as an example, where you want to make sure that they can't later say, well, I never understood how this would affect me and the other children. So yes, you do advise them, this is your decision, but do they understand how the decision impacts their estate going forward? That's the other piece. That then you got the slam dunk defense, Matt, because not that I'm trying to sound like clients are untruthful, but they just sometimes have different ideas about what was discussed or how things impact them, that a written communication is just vital to have in your in your pocket, and also as a duty as the lawyer to make sure that the client is making an informed decision.
Yeah, you bet. And that, the informed decision is important throughout the representation, beginning, middle, and end. Bill mentioned conflicts of interest that arise, especially when you're representing a client and his or her partner, and how exactly you can accomplish representation. It may be that you can, and that despite the concurrent conflict or potential conflict, how do you go about fixing that? Well, in the rules, just be aware that when there is that concurrent conflict, that the informed consent actually comes into play, and that's defined in Supreme Court Rule 20:1.0F, and you can see it. It's very broad. It's an agreement, the client's agreement, to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. So that's a lot, and I think that's the point of informed consent, and that is to be thorough, to cover as many options as you can and the ramifications of each one, so that there can't be any argument that the client down the road who becomes unhappy with the lawyer's services wasn't informed about what exactly was happening, and be sure that when that informed consent standard applies, that you meet it. Bill, what is your practice when things change? So you've got a perfectly crafted engagement letter. It identifies the scope of services, to the T, and there suddenly is something else required, or some other legal need that the client expects to be serviced. So we've got the engagement letter. What do you do when you change the scope of services?
The simple answer that is rarely followed in practice is that you update the engagement letter. There should be standard language in your agreement that says, these are the services we're providing, and if we agree to provide additional services, we will have a further written agreement. So you should update your engagement letter. This is all happening on the fly, and we've all had this. You're working on someone's estate plan and they've got a real estate matter. It's within your scope of competence, but man, you got 10 other things going on today, and you're just going to start working on it. And you need to take that step back and update the engagement letter. It doesn't have to be fancy, but you need to have it in writing that this representation now includes this real estate matter, even if it's a little one. You just need to do that to protect your cover that your engagement letter or letters describes the scope of representation. Because if you change the representation and don't update it, there's a concern that you're going to lose that protection that you have limited the scope of the representation. So it's critical at each step, if the engagement expands, as they often do, that the scope of representation described in your letter expands accordingly.
And then I think, just to button up the whole engagement change in scope of representation, and then the disengagement letter, we definitely encourage, whenever your representation is done, button it up, close it, send the disengagement letter. My services for you are now complete. Thank you very much, for thinking of us. And if you have future legal needs, please don't hesitate to contact us, or something like that. It does need to be brought to an end, because if there's some other issue that might be contemplated in the representation, the client doesn't have any question then about whether or not they have to enter into a different agreement for those services. So yes, write all of those letters. They can be reduced to templates and handled in the ordinary course of your business, so that they don't get overlooked. But it is important to do that in every case.
If I can add a comment on that. Remember, all of this standard of care is subjective and client focused. I would say that most people, a lot of people, will presume that if there are significant changes in the law that affect their estate plan, you're going to reach out to them and tell them. If that's your practice, then define how you do that. If, on the other hand, you don't plan to do that, and I've made the decision that I don't because there are too many variables. You need to say in that disengagement letter, it is not our practice to advise people of changes in the estate tax law that might affect their estate plan. If you have questions about developments in the law or there are changes in your circumstances, you can contact us because, you'd like to have them come back, but don't fall into a trap where they can say, well, the tax law changed and he didn't tell me and I thought he was going to tell me. You don't want to be there. You want to be able to point to your letter and say, no, I didn't sign up for that. You didn't pay me to do that. And I didn't do it because we agreed that that was not the scope of my representation.
Exactly right. Okay, I want to shift gears here and start talking about ORIC and its progeny. And ORIC is the case that actually opened the door a little bit for some of these claims that Brian and Bill have been talking about, where the exception to the general rule that the only person that can sue their lawyer is the client, and this opened that door just a little bit. Liability is imposed on an attorney who acts negligently in drafting or supervising the execution of a will, and lack of privity will not bar a claim by a disenfranchised beneficiary. So I'm not going to continue to talk about this because I think Bill and Brian are smarter than me as far as this goes. Brian, I think that's recorded, so you get to use that against me in the future. But what are your thoughts, both of you, on what has happened with ORIC? Bill, I know that you're not so keen about the McLeish decision, but what has happened now with Rauch, and what's the current status or landscape of legal malpractice claims as it relates to estate planning?
Brian, do you want to go first, or should I launch into this?
Oh, sure. Go ahead, Bill. Now that I'm pretty much done when Matt said I'm smarter than him.
McLeish was sort of the last word we had on the law in this area until earlier this month. And there were some real concerns about some of the language in that case that could have been construed pretty broadly. And, we've had this progression. There are cases where someone botches a will execution or something, and the non-client disappointed beneficiaries have a claim. That was extended to trusts. And then the law extended to gifting and the administration of an estate. And it looked like this was just turning into a wide open free-for-all. And now on the 15th, we got this decision called Rauch versus McNaughton. It's not recommended for publication, but it is not a per curiam decision, so it's citable, where, just briefly, a client's son sent documents to the defendant attorney, including a written signed document from the client that said, I want to change my estate plan to further benefit this particular beneficiary. That didn't happen. And when the client died, that disappointed heir, who was already an heir under the current will, sued the attorney, saying, well, this is covered under the ORIC exception. And in this decision, the Court of Appeals upheld a trial court decision that said, no, since this additional bequest, we'll call it, it's a little imprecise, was not reflected in a will or similar estate planning document, there's no claim. And it dismissed the claim at the pleading stage. So here we have, one of the things about the way this law was going was that the standard was whether the lawyer's actions frustrated the client's clear intent. Well, it's clear that at least at one point, this client wanted to increase the benefit under the will to the plaintiff. And the lawyer didn't do it for whatever reason. And the Court of Appeals upheld the decision that said, we see all this. There's still no claim under the ORIC exception because it was not reflected in a will or similar estate planning document, even though it was reflected in a signed writing from the client. This, I think, addresses a lot of the concerns that I had about the expanding scope of these claims. It doesn't take the area of law away by any means, but it certainly limits the ability of people who think they should have gotten more from a testator to sue that testator's lawyer. Now, this case, the appeal deadline hasn't run on this, and I'm waiting to see whether it gets appealed or not and how it would do if it were appealed. But I find this an encouraging decision in this area of the law.
Yeah, Bill, and it's something we've tried to we've defended cases in a similar context successfully, I might add, without this case, only from the idea that it's pure speculation then as to why mom or dad or whoever didn't execute a certain document that was, it's just the person's not there to answer that question. It's speculation if it's not, if there's no extrinsic evidence, right? Is that what would be the idea
That's
behind it?
Yep.
Yeah. But, yeah, I was surprised. Were you surprised? I haven't had a chance to talk to Bill about this decision yet, but what were your thoughts on that decision?
I was surprised. I was actually very surprised because I saw the law heading toward, people reading the restrictions that were put on these claims out of the law, and it just being a question of, okay, what was the testator's intent, and did the lawyer's actions frustrate that? And that would have led to all sorts of problems exactly in the nature we're talking about. Somebody finds, a note in somebody's trash can that says, I want to give Timmy half of my estate. Well, there's a clear expression of intent, and the lawyer didn't do it. Well, this decision would protect lawyers from liability or even a claim in that situation because it's extrinsic and it's not reflected in a will or similar estate planning document.
Yeah, and I think, Bill, the facts you just described that were in this decision are so similar to what we see, where all of a sudden the lawyer gets a call and says, oh, we just want to chat with you briefly about what you did or what you didn't do on this estate matter. And the lawyer, trying to be helpful, starts talking a mile a minute and looking at his file. That's where you need to, including this decision might protect you, is stop, report this matter to your carrier. Hopefully you're with us. And before you say anything to anyone, you got to realize you're being set up potentially for a claim that may not be able to be established, but for your own testimony that could work against you. So you want to be helpful. I get that, but there are certain limitations about what you should or shouldn't provide in terms of attorney-client relations and protections, privilege. But secondly, you want to know that you may have protections in the law that are important to avoid a claim in the first instance. And so don't just voluntarily step forward and open up your file in your mouth and provide information without thinking about the ramifications and potential claim exposure, including what we've talked about earlier, the amount of money that is being spent to pursue these types of claims against lawyers. You want to take this as a positive protection and get good counsel, like a guy like Bill or with WILMIC, so you don't get yourself in a bad situation that may be totally defensible based on the landscape of the law.
Bill, when I read the decision, some of the facts that jumped out to me it had to do with the health of the testator. If I recall correctly, it was declining pretty rapidly, and so this change to try to add an additional $500,000 to the third party beneficiary. I think from a human perspective, dad and son tried to address a problem while dad's health was declining quickly. how does the health of the testator or the client impact the lawyer's practice, and should there be a little more urgency, and if in fact the lawyer is convinced that this is the exact change that the client wants to accomplish and that the lawyer has an obligation to accomplish it. It seems to me that should, that we should no longer rely on, any sort of letter communication, as formal as it may or may not be. But as the practicing attorney, that should be reduced to some kind of estate planning document. Otherwise, it will run the risk of dismissal, just as the Rauch court did.
This is a double-edged sword. There is no doubt that if your client is in failing health, that you've got to move. If you've got to make a threshold decision, do I have time to expedite this matter? And if the answer is no, then you should decline the representation. If you're just too busy to get to somebody who's in hospice, you should send them to someone else. Maybe you can send them to someone else in your office or send them out, because there are cases where, someone drafted up the will and set up a will signing appointment, and the client canceled it, and 2 days later they died, and that was a malpractice claim. So that's the first thing. Can you do it? And the second thing, though, is that if someone's health is declining, you've got to be confident that their testamentary capacity has not declined to the point where they can't do this anymore. Remember, you are the determiner of whether that person is competent to make this document or not. And when someone's sick, they've got to be competent at the time they sign the document. And that is a determination that you, as the attorney preparing and overseeing the execution of the document, have to make. And sometimes, as hard as it is, you're going to have to say, I'm sorry, but my professional opinion is that you are not up to doing this today, and we're going to have to set another date. And if they pass or become completely incapacitated after that, that's not your problem. As long as you've acted reasonably and made reasonable efforts under the circumstances, if the client doesn't have the wherewithal to do it, you shouldn't do it. So you've got to, what's the phrase? You have to use all deliberate speed, but you do need to deliberate as you proceed.
That's a good description. So as to competence, obviously we're lawyers, we're not doctors. And so what factors do you take into consideration when you're making that determination as to competence of the client to do what they're asking you to do?
I mean, the first thing is you or whoever in your office is managing this has got to be communicating directly with the client. Mom wants X, doesn't cut it here. And it really doesn't cut it the closer you get to the time of execution. And then, it's the standard testamentary capacity test orientation to time and space, even though, someone botches the day of the week or something like that. Is that a concern? Well, it may heighten your awareness. Are they aware of who their typical beneficiaries are? That's a pretty easy walkthrough. If they don't remember that they have 3 kids or don't remember one of their kids, that's a flag. Do they have some sense of what their assets are? Not to the penny, but if they don't remember that they're the majority shareholder of the family small business or something like that, you've got a competency issue on your hands. But although people use health professionals on these competency questions all the time, the case law is that it's a legal determination, which a lawyer who's overseeing the execution of the document is competent and has to make.
So I heard awareness of assets, orientation to time and space, and then memory. Right? Do they actually remember, who the subjects are, who the beneficiaries are, et cetera? Is there, I know there's no magic question or magic set of questions, but really it is a sort of a judgment based on these collective factors. Is there benefit in this day and age of multimedia to recording videos and asking questions that are recorded in that way. Does that help support or buttress the lawyer's conclusion as to the determination of competency?
I don't think that's an easy answer. I mean, I think a lot of people love video, but here are some considerations. First of all, I'll mention Brian and I have an unscientific example of this where what looked to us like completely compelling video evidence of somebody's wherewithal and intent hasn't prevented a case from moving to trial. That said, you also need to consider whether you've got your video process set up as a regular business practice. If the only estate plan you do it for is the one where that's in court, you better be able to explain why. You can say, well, we do this whenever we think there might be a question, and it turned out we're right. But if you've only done it once, that's going to look kind of weird. The other thing is you've got to be careful what you ask for, because if you turn that camera on and your client gives an answer that's totally out to lunch, what are you going to do with that? Are you going to erase it? And then have you spoiled evidence? These are things that you've got to think about before you bring that video camera in. I mean, I think we're probably heading that way since it's so easy to do video now, but be careful what you wish for.
Thanks, Bill. So Brian, we're coming up here on 10:15. We've got about 8 minutes left, and I wonder what your thoughts are on where this is headed. Using recent years as an example, we have seen these claims only increase, and I wonder if you can offer your crystal ball about whether you see this sort of leveling off, or is this case law development in the Rausch case something that's going to slow it down? Is it too early to tell? And what can we do to help our insureds avoid any sort of mistakes that might lead to these kinds of claims? What are your thoughts about your best predictions about where this is going?
Well, I think Rausch maybe is a step in the right direction for sure. I think there have been some excellent points made. I'm not saying by me, by Bill, but about steps to take to try to best avoid a claim or defend a claim or grievance, knowing that and I hate to sound so defensive, but the reality is that I think the estates are, if anything, going to continue to be large and get larger, especially with what's happening with real estate. So to think that these claims won't continue to be brought would be naive. So you do have to be, sadly, protective if you practice in this area. And I think you're not doing anything different. You're just trying to make sure it's preserved as to what you did, why you did it, and who your client was. A lot of these are just solid points to protect yourself and your clients. And then the litigation costs is what worries me. And I know we've talked about it already, but where someone doesn't have a lot to lose, they're disinherited, so they're getting nothing. They get a firm to take their case on a contingency fee basis, and then run up and they're told, hey, you might get a lot of money, pursue this, and don't worry about fees either, because we're going to collect all those against the attorney that messed up your estate. So there's a lot of incentive to pursue these kind of claims, possibly a large upside. And these steps to take a second, document, communicate are so important when you're on the other end of a deposition or a claim. You're going to be so glad you did. And I think I like that last segment about the urgency. So, because we have several claims right now pending whereby things weren't done, something happened to mom or dad, or they're no longer competent when it came time to execute. And the lawyer probably in hindsight would have said, you know what, I was real busy that time. I had a lot of things going. I wasn't going to be able to get to it. I did understand that this person was of ill health, Matt, you brought up that where their ill health or their competency seems to be maybe going in and out, and you're not going to get to something for a while. Boy, I had to say that there's 100% of the attorneys that I'm thinking about that have the claims that fit that circumstance would have said, you know what, I should have just said, I'm not going to be able to get to this. I'm sorry, but, or if you do take it on, as Matt pointed out, you got to get to it because you already know now there are facts that may mean that the standard of care is going to be elevated. So just take particular caution when there's a situation where someone's on their deathbed, because that's a problem, but that's not your problem unless you make it your problem. So maybe you don't want to take on that problem because you do have a busy life and practice and you have a vacation plan. That's fine. That's something you should pursue, but don't take on this issue if you can't get to it right away, because years later, and when these things drag out, and Bill, I'm thinking of one we're working on right now, these drag on forever. The attorney I'm thinking of the one case, Bill, we're working on, would love to be done with this thing. So anyway, a decision now can affect you for years forthcoming. And so make sure if you're going to invest in an estate matter with an urgency issue, you get after it or you get out of it. That would be the best advice I could give on that.
Yeah, good points, Brian. I do want to address a couple of questions that have come in late here. One is, if the client does not have the capacity to sign on a particular day, shouldn't you also be documenting that in either a memo or somewhere else? And I think the short answer to that is yes. But Bill, what are your thoughts on? Do you send a letter to the client, or look, I've reached the conclusion that you don't have the capacity to sign, and so I can't take this on, or what should be communicated under those circumstances?
It's absolutely got to be documented in your file. I mean, what you communicate to the client, if they're incompetent, they're still entitled to know. And you may, depending on this, whether your client is okay communicating with third parties, if a child is helping bring people to the meeting, you need to tell them, look, I met with your parent today and I determined they were incapable of signing. We can talk about whether we can reschedule, but as of right now, your parent is not up to it. And let that person who's been involved in the planning, if your client has consented to that kind of disclosure, let them know. But you absolutely have to have it in writing in your file. I met with X on this day, and and write it that day. Don't write it 6 months from now or after you get the summons. Write it the day that you have the meeting or the next day. But yes, absolutely, it's got to be documented. And then there's some considerations about how much, if anything, you say to anybody else, but documentation is critical.
Okay, and then last question, does it help to include a clause in the will which states that anyone contesting the will takes nothing?
Those clauses can be enforceable under Wisconsin law. They're disfavored. But again, it's a facts and circumstances test. I have plenty of friends in this practice area who think those things are a waste of time because they don't work. I have others who swear by them. It's really kind of a personal choice, but it is not ironclad and it's not bulletproof.
All right. Brian, any parting shots besides the one that you already gave?
No, the last one is make sure you notify your carrier when and if you're concerned about an error, a mistake, or being asked to provide testimony or your file materials. Put us on notice. Most of the time they don't end up in a claim or grievance, but you have a policy, you should use it, and you have resources that we can help connect you with to get through that process.
Yeah, you bet. Most of you, if not all of you, are insured with a claims made and reported policy. And so for whatever you want coverage for, you've got to report. Otherwise, it doesn't trigger the coverage. And so you want to make sure that you have a good relationship with good folks like Brian, so that there's no fear or hesitancy to pick up the phone and give us a call. Chances are Brian's been there, done that. and is in a position where if he doesn't know how to help, he can find somebody who is. Real quickly, I don't know if we can answer this one in a minute or so, but it says, can you include a clause that the prevailing party to a contested estate plan document recovers reasonable attorney's fees?
I think you can include it. I don't think you can count on it being enforceable. There's case law to support that, but I'll tell you, if it's a debatable claim, you're not going to get it.
There you have it. All right. With that, we will take a 15-minute break. We'll be back at 10:30 to listen to Courtney Risk Easterling, owner of Dahlia Training and Consulting, and our CEO and president, Tom Watson. Deep breaths won't get me out of this mess. A practical discussion on lawyer well-being, a very important topic. And I'm happy that they will be joining us in about 15 minutes or so. Big thank you to Bill Williams and to Brian Anderson for making this a very informative and sometimes entertaining presentation. Big thanks to you both. And with that, we will end this portion of the program, and we'll see you back in about 15 minutes.
Thanks, guys.
Thank you.
Stephanie, if you can just give us a heads up when you're going to start the recording somehow, some way, then I can hand it over to Tom. And good luck, Tom and Courtney. I hope you have a great session.
Thanks, man.
Thank you.
Yeah.
Great, guys. Thank you. And let's go get started on our second panel.
All right. Thank you, Stephanie. Thank you, Matt, Brian, and Bill for the first session this morning. Welcome back, everybody. It's time for session number 2. I am Tom Watson, President and CEO of WILMIC, and we're happy to have all of you on board for the second half of the seminar today. We're switching gears a little bit. First session was estate planning. We're going to talk lawyer wellness, well-being, life balance, all of those things. And those things do tie into your actual practice of law on a day-to-day basis, and also it can certainly lead to malpractice claims or other issues that can come up. And we'll talk about what we see and how that's all playing into it, and how we can do things better. We're all in this together. We're part of the legal community in Wisconsin, WILMIC is, and so we want what's best for all of you. And I think as we were talking during the break, this is a topic that at one time was sort of a taboo subject. I'm old enough to remember the 80s and 90s, and back then, lawyers who might have been suffering or feeling stress or anxiety or worse with substance abuse and whatever, nobody said anything. And now I like the idea that we're doing CLE programs on it. We're talking about it with each other and trying to help each other cope through this stuff. And so I will be here to throw in my 2 cents when it comes to how we see this stuff play out in the malpractice world. But our main speaker today is Courtney Risk Easterling. Courtney, welcome.
Thank you.
Courtney is a lawyer, a yoga teacher, and she's owner of Dahlia Training and Consulting. She's based in Lexington, Kentucky. Courtney also at one time worked for the mutual insurance company in Kentucky that provided legal malpractice insurance to Kentucky lawyers, as we do here in Wisconsin. Her company now offers employers and law firms a variety of consulting services aimed at tailoring solutions to business and practice management. Courtney's got background in legal ethics and risk mitigation, and so her company has partnered with the Utah State Bar to support their ethics hotline. It provides members with general guidance on ethics issues. Dahlia also leads training sessions across the country, including CLEs, focused on the ethics of practice management and the connection to lawyer well-being. So she is certainly someone with a lot of deep knowledge in this field. And so, Courtney, we're anxious to hear your thoughts. I'll just say a couple of things first before I throw it over to you.
Yeah, absolutely.
From WILMIC's perspective, when you talk about balance, we never really achieve perfect balance, but you try to, at least my personal view is, you try to achieve balance as best you can. Uh, when I'm around the state doing programs or I'm at conferences, I meet a lot with lawyers and particularly younger lawyers I find who many of them, this was a surprise to me at first, but now I've heard it enough that it's out there, and that is younger lawyers in particular. Many of them tell me they regret going to law school. They wish they would have taken a different path. They're finding it to be very stressful, very anxiety inducing, and I think that some of them are having trouble coping. And so this is, as I said, a topic that needs to be addressed to help them and others deal with that kind of stuff. Balance is such an important thing, and really what I'm here to talk about is how that plays into things like calendaring and being, not letting your calendar take control of you, which happens. So many of our claims are because of missed deadlines. And you say, well, how do you miss a deadline? Well, it's when things get too overwhelming and your calendar kind of gets away on you and takes over control of your life. And so that's a problem. Then there's client selection, making sure you're choosing the right clients and time management. So those are all things that I think in some way or another weave into wellness and well-being. And so I can jump in on some of that as well. But in the meantime, let me throw it over to you, Courtney, and you can give us a lot more depth as to
Sure.
how this works and how it impacts people.
Absolutely. And thank you all so much for asking me to speak. I'm happy to be here. I do still have my Lawyers Mutual of Kentucky mug here that I'm drinking out of today. So you'll see that flash up there. I have really enjoyed working with a mutual company. And so to have my first, because I just left Lawyers Mutual earlier this month. And so to now be speaking to WILMIC as my first legal ethics CLE under this new adventure is super exciting, and I really appreciate you all, and thank you, Matt, for making the connection.
Hey, Courtney,
So
before you go on, let me just quick tell
Yeah.
people, and they probably know this already from the first session, but if you do have questions, hit the Q&A icon on your computer screen and go ahead and submit that question, and Courtney and I can field those as they come in. So, all right.
Absolutely.
Sorry to
Perfect.
interrupt. Go ahead, Courtney.
No, jump in at any point. So if none of you, I'm guessing maybe none of you have heard me speak, but if you ever see me again, you will hear the same disclaimer over and over and over. I always said that I like to model what we were preaching, especially when we're thinking about malpractice and legal ethics and preventing the inadvertent creation of an attorney-client relationship. So I am not your lawyer. Tom's not your lawyer, but we are here to help, especially as a WILMIC insured. I am confident that you know, and if you don't, here's your plug that you can always reach out to WILMIC. See, I'm going to say LIMIC all throughout this because that's what I'm used to saying. You can reach out to WILMIC and ask questions, and then if there's anything that I can help from my perspective and what I do in my training and consulting, I'm also happy to help. You've got my email address in the written materials. So here's kind of a lay of the land for where we're going to head today, just a kind of broad overview. So we're going to start with a poll here in a second. We're going to talk about well-being, talk about why are we talking about well-being in this connection to ethics and malpractice? How do we get ethics credit for this, which I think is the most fun and entertaining way to get ethics credit. And then we're going to think about practical tips to improve well-being on the individual level, and then kind of go out from there, looking at firm-wide and then profession-wide things that we need to think about. So first, for those of you who want to play along, hopefully several of you will, there's a QR code on the screen right now. So I am confident that you all have a cell phone nearby that you can you can pull out your camera app and get the link for this. I'm going to pull up a poll. It's going to generate a word cloud from us, and I'm going to change my screen. So how would you describe your current well-being? So I tested it out. I felt balanced. but I'm not practicing law anymore, and I'm doing my own thing. And so that's probably why I feel that way. So we'll give a few minutes to have these start to populate. But I think it's interesting. Tom mentioned, that a lot of young lawyers wish they hadn't gone to law school. I don't litigate anymore. I started my career in litigation. I've been an attorney for almost 10 years now, and I do love the law. But I'm excited in this role to try to make it, to help improve the professional landscape so that it feels less overwhelming, tiring, right, to practice law. So I'm loving all the words that are coming in. There are a few that are feeling good, good, excellent, lots of exhausted, stressed, burned out, right?
Yeah.
Stretched thin.
Yeah.
Right. So keep submitting your words. I will, at the end of this, I will be posting on LinkedIn this word cloud so you can see the final result. So if yours hasn't popped up yet, you can go ahead and do that. I'll switch my screen back here. So overwhelmingly, there's usually a mix when I ask that poll in a session. There's a mix, but by and large, the majority of attorneys feel overwhelmed, burned out, stretched thin, right? Those are very common feelings that we hear when it comes to attorney well-being. And so one way that I have found that is beneficial to frame this discussion about well-being is this term languishing. And looking at, are you flourishing or are you languishing? So back in, I want to say 2013, Corey Keyes is a sociologist who coined this term called languishing, which means a lack of good mental health, right? So, maybe you're not on the end of the spectrum where you're in full clinical depression or having diagnosable issues, but you're also not flourishing. And your written materials go into this in a lot more detail. But generally speaking, flourishing is you feel happy more times than not, right? Flourishing doesn't mean you're happy all the time, but it means more often than not, you're happy. When you're flourishing, you feel like you have good mental health, that you are free to pursue your passions in one way or another. You feel like you have more good days than bad days. Languishing is when that sense of well-being, that sense of good mental health starts to shift away from that, and you start to feel like you have maybe more bad days than good days. You don't feel like you can pursue your passions. You feel like at every turn something is going wrong. Like you'll go through your day, and no matter what, every little thing is going against you. You feel like everything is extra effort. You just can't get ahead. You're starting to feel overwhelmed, right? So if that's the case, you might be in the space of languishing. And it's important to acknowledge and recognize that languishing is not an actual diagnosable term. You're not going to find it in the DSM, but it's this concept of starting to slide back on the spectrum between good mental health and falling into something like depression, anxiety, or other diagnosable conditions. So you're starting to slide away from flourishing and into this kind of, maybe we're starting to skirt on the edge of something where you're kind of teetering. And the reason it's important to think about this and recognizing these signs of languishing is that you are significantly more likely to experience a major depressive episode once you're in this space of not having good mental health. It might just take a few more, like one little thing going wrong to kind of tip you over into really falling into a more depressive state, something where you're going to really have to have some serious work to get yourself back into a good mental space.
Courtney, I think languishing is a good word to describe some of the younger lawyers that I run into.
Yeah.
They don't feel overwhelmed to the point where they can't function, but it's hard for them to identify a really good day for them.
Mm-hmm.
And they wonder, where am I going?
Yeah.
where is this leading to? They
Yeah,
don't feel that they're making progress. They're pushing the wheel up the hill, but it's not going anywhere. And
exactly.
that kind of feeling it's difficult for me to hear them say that because I feel the stress for them.
Yeah,
I at one time was a young lawyer too, but it's tough for them. So I think languishing captures it pretty well. And as
absolutely.
you can be sort of in the middle of languishing and flourishing, right?
Absolutely, absolutely. And I think there's another presentation that I've done that dives into that a little deeper. There's this great graphic of this guy just like slouching in a chair and going like meh, and that's kind of the best visual for languishing, right? It's just like you're kind of meh. You're not getting excited about things that used to excite you. You don't have time to follow your passion to kind of fuel yourself, right? You feel like you're in this grind and you're not getting anything out of it. You can't quite find your, like you said, your purpose. So yeah, I do think that this resonates, and I think it resonated with a lot of people during the pandemic. So this term was coined back in 2013 or so, but it became really much more popular and got some additional visibility during the pandemic, because I think a lot of us found ourselves kind of as, at least in this temporary state of languishing, because our normal routines were so different and we weren't able to, maybe some of the things that we had passion, we weren't accessible, right, during shutdown or whatever we were experiencing at the time. And so it was written about in a New York Times article, and it's kind of taken off since then. And I think it really does resonate with so many of us. I am technically still a young lawyer in the state of Kentucky because they have very generous provisions of who is a young lawyer. I don't feel young most of the time, but I do, when I interact with those younger lawyers, hear that this is something that they're struggling with. Absolutely. So I think it's across the board. It's not just in Wisconsin. It's here as well, for sure.
Yeah, and I think there's a feeling among some lawyers, many lawyers, they wake up in the morning and it's hard for them to get excited to come into work, to come into the
Mm-hmm.
office. And that can lead to so many things. And we have lots of claim statistics to show how that manifests itself, but it's out there.
Absolutely. And that's the perfect transition, right? So that is why it's so important as lawyers, because of our professional duties, our duties to our clients, the work that we do, we have to maintain a certain level of good well-being. That's not to say that as an attorney, you're going to have you're expected to or should have great days every day. And if you come in super chipper every morning, I'm actually going to worry about you more. I'm suspicious of those people because it's not real life, I feel like. Um, we're all going to have our bad days. But you do have to find some level of satisfaction to keep you motivated to coming into work every day so that you can be meeting these obligations and mitigating your risk on the malpractice side of things.
I, I might be a little late on this, Courtney, but we did have a
No, you're good.
and
No,
we
go
kind
ahead.
of passed that, but a couple of people asked for that QR code back. I know
Sure.
we're,
No, that's okay. I can flip back.
yeah, maybe they want to chime in here.
Absolutely. So I'll leave
Sorry,
that up
folks.
for a couple of
I'll keep a
couple of
closer eye on
seconds.
these on the questions. I should have.
Thank you. Yeah. No, it didn't pop up for me either. So thanks for catching that. All right. So hopefully everybody captured that. We'll sneak on forward here. So we'll start with the ethics rules first, and we'll kind of talk about malpractice. There's definitely a connection between ethical violations and our duties and ethical rules and malpractice, although there are other things outside of ethics rules that impact malpractice, right? So it's a broader conversation, but the ethics rules I find is a good place to start, because the main rules that are implicated when we have poor mental health or poor well-being is, our competence. If you are struggling, like you said, Tom, if an attorney is struggling to find the motivation to go into work, right? How are they able to be competent, clear-headed, meet that duty of competence, meet their duty to understand and have the knowledge and be on their toes, right? To respond in a way that their clients need them to. Diligence is another duty that is impacted for sure. Thinking about maintaining and staying on top of your workload. I believe you all have the same comment in your roles that we do, that procrastination is disfavored. And so we have to make sure we're controlling our workloads in a way that we can stay on top of it. And as you start to slide, as your well-being starts to slide and you start getting behind, it is really, really hard to get back on top of that mountain, right? Like if you have that drawer full of envelopes that, or, you just haven't gotten to that stack of mail and it just piles and piles and piles because it just keeps coming, right? It can get really overwhelming and become paralyzing. That's an extreme example, but even if you're not in that extreme place, if you're not motivated, you're not working as efficiently, you're probably not going to stay on top of your workload and you're always going to feel just a little bit behind. And that grind can be hard as well.
Yeah. If I can just comment on these briefly, Courtney, communication is the biggest one for us. Roughly 30% or more of our claims are due to communication problems, whether it's miscommunication with clients or lack of communication, whatever it is. It's an overwhelming amount of claims that we see that deal with communication problems. So that's a big one. Competence and diligence. Yeah, we have ethics rules in our professional rules of responsibility in Wisconsin. I have found it interesting in the last couple of years that our competence and diligence language in those rules, they never really say anything about wellness, and maybe they don't need to, but for instance, the competence rule that we have says a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And then diligence says a lawyer shall act with reasonable diligence and promptness in representing a client. Obviously, we need some level of wellness to be able to meet those obligations, preparation and promptness and that sort of stuff. But I just wonder if when you read that stuff, there's no mention of wellness, and again, maybe that's just not, there's no room in the rule for that sort of thing, but it ties together.
Yeah. And so it's not explicitly adopted in Kentucky. So they put before the committee last year, and they declined to adopt some additional language under competence that specifically would reference well-being. And I believe that stems from the ABA model rule has adopted some language to specifically address well-being. And I think some of the concerns were, the downside to that by putting it explicitly in the rules is how far does that go? Could someone file an ethics complaint because of something that really doesn't impact that person's practice, right? So there was some back and forth about that. And so as someone who used to work on the carrier side, I can appreciate those arguments as well. But diligence does in the comments talk about that managing the workload, and we'll talk about that as part of the practical tips, right? Making sure you can't diligently represent a client if your workload is so out of control that you can't provide the time and focus on that case that it deserves so that you can provide competent representation, right? So I always think of 1.1 and 1.3 as intertwined, and it really tied into how you're managing that workload. That is an ethical duty that we have, right? And that to me is how I've always argued that, well-being is part of our ethical duties, even if it's not explicitly in the rules, because if you have that poor mental health, if you're starting to slide back from having good well-being, if you're sliding away from it, if you're feeling burned out, if you're feeling stretched thin, are you able to provide competent, diligent representation to each and every one of your clients in a way that meets your ethical obligations? And oftentimes we can't. And so we have to readjust in some way. And we'll talk about ways that we can do that. And here's the malpractice piece, Tom, for you. So here's your all's numbers on claim severity by areas of practice. But as we've touched on, well-being impacts malpractice claims as well.
It does. And this is for last year. So these can vary from year to year. Obviously, over the course of our 38-year history of WILMIC, personal injury practice has always been right up there amongst the highest. And this pie chart deals with dollars paid out, not frequency, but rather how much these cost us. And you'll see personal injury is right up there. Construction is high for last year, but it can be skewed sometimes if we get a rash of a few of those. It skews the numbers. That's not always up there. But estate planning that Bill and Brian and Matt talked about in the first session is always up there along with personal injury, as is real estate. And so, and family law last year was only 5%, but in past years, family law has fluctuated a bit. It's oftentimes in our top five, not every year, but oftentimes it is. So family law can be a generator of claims too, and that's an area that obviously is one of high emotion, as is estate planning at times, and personal injury. And so, if lawyers aren't in a position, whether mentally or not, to deal diligently with those issues, and competently, and be prepared, and are not overwhelmed by their calendars, that they can deal with those. But if the opposite is true, then sometimes we see claims come in these particular areas of law.
Absolutely. And another piece of that to me as well is, you think about these higher risk, these higher severity types of cases, plaintiffs' attorneys, estate planning attorneys. You said oftentimes family law is in that top section. You also are in a position, not just all the work piece of what you're doing, right? You're having to have that client interaction in a way that can really impact your well-being. And you have to find a way to handle and manage that relationship that can become very personal. Not to make over generalized statements, but I'm going to. Oftentimes in those practice areas that are higher risk, you also have clients who can demand more of you as an attorney, more interaction, more explanation, more hand-holding in a way that if you don't have good mental health and you're not in a good place and you feel overwhelmed, sometimes those relationships can become difficult to manage, which I think, and Tom, you correct me if I'm wrong, but I think that kind of sometimes then leads to that poor communication, because sometimes you start to avoid that client that's needy, for lack of a better term.
Well, you hit the nail on the head, Courtney, on that. I think what we've seen in recent years is technology driving client demands, and the client demands to me today are more acute than ever before. They text their lawyers, they email them constantly. And I was practicing before I joined WILMIC in 2005. So let's say late 90s, early 2000s. Email was at that time becoming a communication tool, but it wasn't like it is today. I mean, that's all we do, right? Is email and texting, and I don't know how many lawyers out there share their cell phone number with their clients, but there are some. But my point is, the client demands now are as high as they've ever been, and that puts a certain stress on lawyers. A client, I had a guy that he told me after a presentation I did not long ago that he has a client who sends him an email at midnight before they go to bed, and then at 9 o'clock in the morning he calls and says, "Hey, I sent you an email, but I haven't heard from you." And the guy's like, I'm just getting into the office here, and you got to give me some time. And then we always tell attorneys, set the parameters at the outset of the representation. What are the rules for how quickly you respond and so forth. The other problem is a very quick response is sometimes not the best response. Sometimes you need time to do a little research or think it through. But we live in this age now where everybody wants instantaneous communication, what with social media and texting. And so that puts pressure on attorneys, and then they feel the stress and the anxiety, and it all goes hand in hand. And this is a big one for me. There's just the incredible demands that clients are putting on attorneys, and attorneys are feeling that stress, I think, on a regular basis.
Absolutely. And so setting those expectations, we'll talk more about that in a few slides, but absolutely setting those expectations on the outset can be a lifesaver. So first, we're going to talk about what we can control or change individually, right? So some of these pressures, like we've talked about, are outside of our control, and some things are within our control. And in general, and in my viewpoint on well-being, the best place to start is acknowledging, is that thing that frustrates me in my control, or is that an external thing that I have zero control over? And sometimes just acknowledging that piece is enough to give you a little bit of like, oh, well, yeah, I can't do anything about that. But you can then change your behavior and set some boundaries and do some other things, right? So we're going to start from what can we control or change individually. And we're going to think about, first and foremost, if you are struggling, if you're feeling, especially if you're at the place where you are articulating that you are burned out, and I saw a couple of people respond to that, seek out professional help, right? You don't have to wait until you're in a clinically diagnosable place of, clinical depression or anxiety or whatever it may be. You don't have to wait until then before you reach out to see a therapist, talk to someone, right? So those resources are there. I included a couple of links to the Wisconsin Lawyers Assistance Program, as well as the Wisconsin Psychological Association. So oftentimes those statewide professional organizations will have like find a therapist near me. And you can kind of look in and figure out what kinds of things that those therapists focus on and whether it might be a potential good match for you. So those resources are out there. When you think about professional help too, if you're not in a place where you're needing a psychologist, but maybe you're like, okay, I'm starting to see I'm languishing. I want to make a career shift. I'm thinking about, stepping out and figuring out what I want to do, but I don't know exactly what that is. There are good career coaches. There's some people that brand themselves as life coaches, but I've seen some real good success, and I have used a career coach before or a business coach to help me think of that piece, right? So therapists can help you with some of those internal pieces and some life things, but there's also other types of professionals like those career coaches out there that can help you think about, what are you wanting out of your career? How can you articulate that? Does that match where you are now? Do you need to make some other changes in the long term and put you in a place for success that way? You also can review your time management systems. And Tom, I know you've got some thoughts on these as well, because you see this a lot on the malpractice side, but some of this is firm wide. And if you're in a firm management role, it's really important to think about, what is your firm doing to manage your time? What are the firms, if you're doing billable hours, what are the firm's billable expectations? We'll talk about that a little bit more when we think about the firm side. But what you individually can do is, look at what your firm has in place, and are there additional layers of ways that you manage your time that you need to implement for yourself, whether it's how you manage your calendar, how you do your to-do list and the like. Tom, I know you probably have some thoughts there as well.
Yeah, I do. And Courtney, when you first started out about seeking professional help, and you talked about some of the emotions and feelings that were popping up on the screen when you did your QR code poll,
Yeah.
I saw the word exhausted, and I saw a couple other words similar to that. And I guess if someone's feeling exhausted, that's a tough place to be when it comes to trying to help other people manage their issues. And I agree with you. I think professional help is an area to go. And thank you for mentioning WISLAP, WISLAP, the Lawyers Assistance Program that the State Bar has. It's a good place to start if you want to take small steps to getting at least somebody to talk to. The WISLAP program is really good, so I would strongly encourage people to utilize that service at the State Bar. In terms of the time management systems, Courtney, yes. We always tell lawyers, manage and keep track of your time and your energy so that you can maximize your effectiveness. When we talk to lawyers about that kind of thing, time management, we talk about working on organization, because it's easy for so many of us to become somewhat disorganized. I always marvel at my wife, because sometimes our two sons, who are grown and have families of their own, they'll call and they'll say, hey Dad, do you have that old, some document that they need from something years ago? And I'll ask my wife, and she'll go, oh yeah, I can get that. And she'll go into our office in our house and open a drawer and pull out the file, and there it is. And I'm like, I had no idea we even had that. And it's amazing. I'm so glad I have her to be as organized as she is, but that's hard to do. I can't do it. I'm not nearly that organized. And so um, I think many lawyers run into that, but work on organization, have a system, stick to it. I know that's tough sometimes, but I think that's important. And then we talk about managing the paperwork, all the incoming documents. Make sure they find a home. It's easy to have a desk full of papers, and you don't, you get some documents, you put them aside for the moment because you're busy with something else, and then they sort of get lost in a pile. And then things kind of build up, and pretty soon the stress of all that is just it's tough. So don't leave those floating around. Find a file, get some type of organizational system. And if you need somebody like my wife who keeps me organized, that can help you, I think that goes a long way too. And then there's tickler systems, there's checklists that you can use. Those are all things that can help. I think at least it helps me minimize the stress when if we have a board meeting coming up at WILMIC, or we have things coming, I always like to put my to-do list together a month out or several weeks out, and make sure I'm checking off that stuff as I go, so that I get all those things done in time for a board meeting or whatever it is that I'm anticipating or preparing for. So those things can help, but those are just things that little helpful hints. I don't know. It's different for everybody, right? A
Right.
check might work for me, but it might not work for somebody else. And I know
Mhm.
you have ideas on how you
Yeah.
can do that for your own
Yeah.
for your own personal, whatever personally works for you.
Absolutely. And I appreciate your acknowledgement that your wife carries the mental load for you. That is what we call the mental load. And so that's the other thing that a lot of us as professionals, if we live in a household where there's two people, and oftentimes there's one person carrying more of the mental load than the other, right? They remember all those things in their head, right?
Yeah.
I was that person in my household. And there are certain things that I had to let go of control and say, it is no longer going to live in my head. So sometimes when we're thinking about time management systems, it can be if you are also the personal household mental load person, are there also some things that you can do on your personal life to manage that? This is not an endorsement specifically, but we use the Skylight calendar and created a household chore list that has everything that has to happen in the morning before we leave in the morning to go our separate ways. And my child and my husband, instead of asking me, hey, what do I need to do? They know now to just go to that checklist. And those are the things that need to be done. Is everything checked off before we walk out the door, right? That works for us. It's a very personal process because our brains all work very differently. And so there are some tips in the written materials I really love. And I think a lot of people do, if you are a list person, really like the idea of like coming up with that macro list, those big items. I need to write a motion for summary judgment, and then creating a sub list under that of what are those smaller tasks, because we often can't block off an entire day to work on a motion for summary judgment, right? That's going to be hard to block off an entire day when you have an active practice. But what are some of the small tasks that go into that? Reviewing X, Y, and Z depositions to pull the quotes that I need, or reviewing X expert opinion to kind of incorporate that, or drafting the fact pattern, drafting the first argument, right? Those sorts of things, you can break it down a little bit, and maybe even come up with templates for things with those macro and micro list items like, hey, I know I need to do a summary judgment. These are the things I typically do. And then using that template to kind of help guide you in the future, right? AI can really help you in this as well. And I'm still learning and playing with options. But there's a couple out on the market now that will help you schedule your day. And so if anybody wants specifics, I'm happy to share those. You can reach out to me. But the one that I use, I put in kind of the same thing. I've got a project, and here are, some of the steps underneath that project. And it will I walk into a calendar that tells me what I need to do. And if I don't get to it in time, it rescheduled it before my deadline for that item, right? So technology, embracing technology and playing with those while also maintaining a mind, you have to be very mindful. You're not putting client information into these systems or identifiable information into these systems in a way that would breach confidentiality or privilege. But using and embracing some of these AI technologies that are coming out to help you manage your time. So you're not spending time like, oh crap, I didn't get to that thing. When is it going to get done? There are some AI software or processes out there available that can help you do that as well. So embracing technology, embracing that AI.
Those are great, Courtney. I have a question for you.
Yeah.
So, the idea of setting a calendar and everything, and we all, lawyers have to have a calendar, clearly.
Yeah.
But we all sometimes lie to our calendars as far as who controls our calendar. When's the last time you had a day without the quote unexpected, right?
Right.
So the calendar doesn't always go according to form every day. And so what are your thoughts on dealing or coping with a day that sort of blows up on you?
Blows up.
You're running along on your calendar and then a phone call comes in and boom, your whole day changes.
Right.
Those are tough.
So that's why I have really loved this AI software that I've started using, because when I don't check off that I've completed it, it will reschedule it to another day for me. And I don't have to use the mental capacity to figure out when else I'm going to do it. And it'll alert me if, hey, by the way, that actually was a hard deadline. You're probably going to have to get that done. Or if I've got a few more days, it will figure out where to slot it in, because you put in information about how long that task will take and when it needs to be done, right? So that's one thing I love about the AI. But if that's not in your wheelhouse, if that doesn't make you happy, one thing that I've done before using some of this AI software is I would put a to-do list or a calendar reminder, 45 minutes, an hour before the end of my day, of like, hey, it would pop up and remind me, okay, you're going to probably be wrapping up your day soon. Here were the critical things that are coming up, just kind of as a reminder to stop and say, okay, this day has not gone to plan. I have not gotten X, Y, and Z done. But I know, and pick out the one or two things that you've got to start first thing the next morning, so that you can make sure that those get your attention first as you come back into the next day. I was also always very protective of my time. The thing that I cite, because this can sometimes be the scariest part, but I was a prosecutor early in my career, and I was expecting my child and knew I was going to be out on maternity leave. And I had judges trying to push me into scheduling things when I knew I was going to be out. And I wanted a buffer of a few weeks to get my feet wet before I had a bunch of stuff on my calendar. And I just said, Judge, I'm unavailable on that date, but I am available starting this date. Whether it's a maternity leave or something else, I think we have to resist this urge of telling others why we're not available. It doesn't really matter why you're not available. It could be because you're going to a yoga class. It could be because you're taking a vacation. It could be because you have a client meeting. That person doesn't need to know. It just needs to be, you have to start to feel comfortable to say, I'm unavailable. I really want to help you and I want to give you the time that you deserve. Let's set this up for a time that I can do that. And here's when I'm available. So I think that's the other piece of it as well.
Yeah, and when these things come up, the client matter doesn't go away or step back and allow you time to regroup or whatever.
Yeah.
The standard of care doesn't change; it's still there. And if a lawyer is having trouble, haven't reached out, hasn't made arrangements to deal with those things, the client matter is still there. The standard of care remains the same, and before you know it, you're in a situation where you're not meeting that standard of care, and that's where a claim or a claim can come up or a case can go sideways.
Yeah, I think that leads really well into our next tip, which is making sure that you're calendaring regular client discussions, right? So I think if you could create an apprentice program for new lawyers coming in, I think every new lawyer that is interested in litigation should be a prosecutor or a public defender for a year or two to get that courtroom experience. And then I think every attorney should be an insurance defense lawyer for a year or two to have it ingrained in them that you've got to touch a file every 30 days, every 45 days, whatever that carrier's expectation is. I mean, having that early in my career, it was drilled into me. It was never I never found myself in a situation where I hadn't touched a file, looked at it, evaluated it at least once a month, because I had that external expectation from the carrier. But it set me up for success that things didn't fall through the cracks, right? I was never in a situation where I was panicked about a deadline because I knew what was going on, and I was continually coming back and kind of having my hands on or having my eyes on that file, having an understanding of, have the medical records come in, right? Sometimes you can just spend 15 minutes glancing at a file, what should be here, what should not, is there anything I need to be doing, and providing a quick update to the client. Some matters you're going to have to talk more than once a month. Some matters maybe not once a month, maybe something longer is more appropriate. You have a feel, though, in handling those matters of what that looks like. And you can set up that system that makes sense for you. But I think if you get into a practice of regularly coming across and talking to your clients on a regular basis, it cuts down on those calls in between because they know that you are going to reach out when, on a regular basis, you're going to get those. They start to have that trust in you. So they're not, bugging you in between those times as often. But it also makes sure that nothing's falling through the cracks.
Yeah, in my nearly 20 years at WILMIC, I don't know how many times I've seen claims where, the heart of the matter seems to be that the client felt the lawyer ignored them for a month or more, and as a result, they assume the client is not handling their case properly when in fact the lawyer might be doing just fine. It never hurts to reach out to a client and just say, nothing has happened yet. We're waiting for this, and this, and I'll get to you when those things develop. At least the client knows that you're on top of it. And it might help reduce your stress as a lawyer. Because if you are neglecting a client, you are, and that can raise the anxiety levels too.
Right. And I can tell this story. It will be new to you all. Everybody, and I feel like in Kentucky has heard this story, but one of my predecessors at Lawyers Mutual, Pete Gullett, who is a phenomenal lawyer. Tom, I'm sure knows Pete as well. He's fantastic. I've learned a lot from him. He was in practice for a long time before coming and working with Lawyers Mutual as the president, the past president. But he has a story of the old dog case. And we all have that one case that oftentimes it's a difficult client, or we just know, gosh, this is not going to be a winner. This is a terrible case. I just want it to go away. And it's just like that sleeping old dog over in the corner, and it just sits over there and it gets shoved further and further down the pile, and you just don't touch it. And those are the cases that then rear their ugly heads because the client realizes you're not actually doing what you need to do to move the case forward. You're missing deadlines. They become unhappy, right? And one of the biggest, one of the most important and simple in theory risk mitigation tools is having that communication with your client. A happy client is much, much less likely to sue you for malpractice and file an ethics complaint, even when you've made some sort of mistake, right? So fostering that communication level is important, and managing your workload in a way that allows you to foster that kind of communication is really important. And we'll talk about what firms can look at for that as well. The other piece of individual work that you can do to support your own well-being is growing your network. I think oftentimes we find ourselves building professional and personal relationships within our lawyer circles. And I think that that's great. But I also think we have to think about not always being in the echo chamber of always being around lawyers, because we can be kind of grumpy. So finding other professionals to connect with in a way that makes sense and makes sense with your time. meeting attorneys, but maybe meeting attorneys outside of your firm, outside of your typical practice area. Finding ways to grow your network and be around people with slightly different perspectives can sometimes help you if you're struggling. It can help you maybe see that there's other ways to do things, that there's maybe something out there that will spark your passion again if you're feeling burned out and like you can't follow your passion in your current role. Networking with other lawyers if you're not happy where you are but wanting to think about shifting to another practice or another firm, but having that network makes you feel more comfortable that you can start to reach out if and when you're ready to make a change from your current position. So I really think that that's a key piece as well.
Yep.
But let's talk a little bit about why we need so much self-care as lawyers. Part of it is that some of this just is hard. You're often day in, day out dealing with people who have experienced some of the worst things in their life. And that's across the board, right? Whether it's, my background as a former prosecutor, that seems to come to mind. But when you're thinking about family law, it is hard work. Hopefully real estate transactions are a good thing, or doing business litigation is a good thing, but sometimes it's because something has gone wrong. Something hasn't gone to plan. Or you're having to handle really heavy topics when you're doing estate planning, right? So it's hard work. And I think pausing and acknowledging the difficulty of the work itself is really important. But it's also, with that as our landscape, we as a profession have not always been the greatest at making sure we have good processes in place to support our lawyers. And this is how I approach this conversation with firm owners, is that you have an ethical duty to ensure that your attorneys, your non-lawyer associate, your non-lawyer staff are meeting your ethical duties, right? So if we've talked about that well-being is interconnected to our ability to be confident, to be diligent, to have good communication, then part of your supervision duty then becomes that you've got to put processes and procedures in place within firms to ensure that everyone working in that firm can maintain some good well-being, right? I think people will push back against that. But for those of you looking for a way to have this conversation internally within your firm, I think it's very legitimate to say we have an ethical duty to do right by the people in this building, to have reasonable expectations around workload and the like, and also having ongoing conversations to ensure that people are doing okay, right? Having those day-to-day interactions so that you can start to see if someone's struggling and be able to provide them or guide them to the help that they need. I like to look at the data. There's a lot more data in the written materials. I'm not going to go through all of it. I wanted to highlight just a few things. But what are employees saying about what they want out of work? What I'm not going to talk about, but what I'm going to point you to is a couple of years ago, Thomson Reuters did a study that was really surprising and eye-opening for a lot of lawyers. It should be linked in those materials, if not reach out, but it looks at what associates are wanting. And it's, yes, compensation, but also lots of other things. So we'll highlight some pieces of that. This past year, the McKinsey report came out on women, looking at some gender differences in the workplace. And one data point that I think is important is that both men and women credit remote and hybrid work with lowered burnout and fatigue, right? So by and large, if you have that ability to flex your schedule to fit your life, that can reduce burnout and fatigue. We'll talk about what that really looks like in practice, but that was what the data showed. The data also showed that women working fully remote cited the benefits of less pressure to manage personal style or appearance. I can tell you that from firsthand experience, that is a huge benefit. Now, I'm not I don't take a whole lot to get ready anyway. But I have friends of mine who at least an hour in the morning to get ready, professionally ready, and then maybe a 30 to 45-minute commute. You're talking 2 hours in the morning just to get to the office to start their day. And that's not including if they happen to be a caregiver or other things that they may have to do in the morning as well. Not having to have that at least a few days a week, that's a huge improvement, right? So thinking about where we can give discretion to allow employees to have a little bit more of their time back during the day to take care of work and personal obligations. There was also a ground. No, go ahead.
I'm sorry, Courtney. That's so interesting. For the last 4 years, really, since the pandemic, I have struggled with, okay, remote work versus the benefits of being together. And clearly there are benefits to remote work. The flexibility that employees and lawyers have is undeniable. But then there's the benefit of us being together in the office and being able to talk to each other at a moment's notice, spontaneously, kick ideas around and all that stuff. And that remote versus in-person working is a debate and a conundrum that I think will go on for quite some time.
Yeah, I agree. And I think
some firms want lawyers back in the office, and many of them have for several years now. Others are still have a remote model of some kind. And I don't know what the answer is, but either way, it can lead to some stresses and some anxieties.
Yeah. And I've got some tips and solutions here in a couple of slides, but I will pause and acknowledge that I hear that a lot, because I speak on that this issue a lot. But I can say when I was in litigation, I would, and this was pre-pandemic, I would go into the office. I was a lower level associate. I'd go to my office, and I wouldn't see any of the partners because they'd all had their door closed and they weren't available. One partner had office hours every day, which I understood because that way he wasn't having someone coming in constantly, right? He's got to focus and do his work too, right? So he had office hours. So we all knew we were all lined up at 2:00 in the afternoon, waiting to go in and talk to the partner to kind of have our questions answered and go in, right? Yeah. So I think whether you're in it can feel more comfortable or feel easier if you're in person, because you have this mindset that we can more naturally have those conversations. But also the flip of that is, if you can just go in and out of everybody's office all the time, are you being productive, or is your brain having to constantly shift tasks all the time, right? That for me was the benefit of remote work, is that I didn't have those interruptions, and I could be very intentional that, like, when I set this time to talk to you, I was able to focus on you, versus if you're coming in and out and I'm like, oh crap, I've got this thing on my screen, but I really also want to hear you, right? So I think whatever we do, however we model it, and there's going to be lots of different ways to do it, we have to be thinking about being intentional with our supervision and our interactions, right? Whether it's remote or whatever, we've got to be intentional that this is something we all have to buy into and make that time for, right? Looking at the ABA caregiver report, it was a groundbreaking report that came out at the end of last year. I encourage you to take a look at it. There's a lot more data points in the written materials, as well as links to the actual report. But when we look at the data of how it splits on gender, of feeling overwhelmed with all they have to do as lawyer parents, and this focus on caregiving roles as like the lawyer parent kind of situation, I think there's room to also do some studies as caregiver of others in our lives, right? Because that's important as well. But there's definitely a split here, which can impact our abilities. And the pushback that I think is important here is that we need more and more workplaces to provide men the flexibility to take on some of those outside of the house roles, so that this will feel a little more even, and that women won't always be holding that expectation to be the one. I'm a lawyer, small business owner, right? I have lots of things that I'm juggling, and my husband, who's not in the law, I couldn't marry a lawyer. God love those that marry us. I couldn't do it. but he works in like a manufacturing, the administrative roles within a manufacturing company. So a very male dominated field. And the side eye he gets when he's like, "Hey, I have to leave a couple hours early. My kiddo is sick." Right? Like there's this underlying, so until we can all kind of have some flexibility, this is a broader societal problem, not always just a lawyer specific problem, but it's important to acknowledge.
The disparity in those numbers it's amazing.
Absolutely. And then here's the data about hybrid and remote work that they found in the ABA study. I'm not going to go through all of it. I will mention there is an increased quality of mental health and decreased stress levels, but there is also this risk of isolation, right? So that is where even someone who, like me, who I am very pro remote work, that gives me pause as well, right? So if we are going to embrace remote work, if we're going to go to those models and find ways to do that well, there has to be some intentional interaction to make sure that our people are not feeling isolated, because that can lead down a really scary road as well. If you're feeling burned out and isolated, that's scary as well.
So remote or hybrid work, that they like the increased balance and mental health that come with it. Productivity doesn't seem to be impacted negatively, but then you have the isolation issue. I guess where this back and forth comes in, is remote work better or not?
Right. Absolutely.
And
that's why that stat is important to me, because I think what has resonated with me and with many others of why remote work is so beneficial, it boils down to giving our lawyers, our staff, the discretion and autonomy where we can, right? So we can't always control, deadlines are external factors, client demands are external factors. Those things are set. We can't always change those. But where can we as law firms be flexible and allow and trust those within our law firm to have the discretion to meet those external demands, to meet our ethical obligations, to meet our clients' needs? I think that's the framework that I think when I see law firms and businesses start to implement that kind of thinking about, focusing on giving discretion to our employees where possible, you start to see a shift in culture and a reduction in burnout, right? So regardless of what model you look at, hybrid versus remote, that piece seems to be where you want to focus, is that discretion piece. So what are some of the key areas to evaluate and address as an employer? This incorporates some feedback from a McKinsey study as well. Address microaggressions. If you don't know what these are, go to the written materials and then shoot me an email. That's outside of the scope of today's presentation, but that is important to make sure you're addressing those within your business. Tracking data, looking at what it is that you're wanting to see improvement and find ways to quantify it as a business owner, so that you can look at specifically representation within your organization, making sure that you have lots of different perspectives and points of view within your staff, so that you can grow and have a richer discussion and a richer work culture. Looking at client succession standards within law firms, and realigning partner requirements as needed to make sure that they're realistic within the workload that is expected. I think oftentimes parents and caregivers in particular are shifting into roles where they may be remote and hybrid, but then they're not getting the same interactions, the same networking, same opportunities that set them up to, make partner eventually, right? So how does that impact? How can we realign those things to make sure that, those who need some additional flexibility are not penalized unintentionally?
Hey, Courtney, if you could just jump back there for a second. I know you're not really in the scope of today, but can you briefly tell me what a microaggression is?
Sure. I'm going to be terrible at doing it on the fly, but I'm trying to think of an easy, quick one. So if you have a person of color in your organization, particularly someone with like textured hair, and making comments about that hair, you may think that you're making a positive comment, but focusing on their hair in a way that you wouldn't focus on or talk about their hair in for other women or other people in the room, that's a microaggression, right? It's that kind of unintentional, maybe intentional, often unintentional kind of interaction that focuses on the differences of that person and puts them in a kind of a space of feeling like they're being treated differently. And so then it starts to lend, that's a very quick, simple, off the top of my head example. There's a lot more discussion within the written materials about what those look like. But it's these small little things, particularly persons of color or other minorities, women will experience some of these interactions and just not feel welcome in their space.
Okay.
Right. So making sure that we're making everyone feel welcome.
Okay.
What do firms need to provide? And I argue this is, required under our ethical duties. Now, does that mean it's truly required? No, but there's a case to be made that by doing some of these things and really embracing it, you will set yourself up for meeting your ethical obligations as well as keeping good employees, right? These tips come from that Thomson Reuters study from a couple of years ago. So yes, compensation is a piece of the calculus of what employees want, but they want constructive supervision, right? They want interactions that allow them to grow. There's a big focus for young associates. They want an opportunity to grow. They want to see a path to, where can they grow just individually, right? Are they going to get growth opportunities to take on more complex matters as they get more experience? Is there a way and is there room for them to kind of continue to get more and more complicated experience? So it can be growth in that way. It can be growth and like, I want to see kind of the path of, if I stay here, where am I going to go, right? Is there a path to partnership or whatever it is within your organization? They want mentorship opportunities. They want that ability to have mentors within their organization. But I also think it's really important to have and encourage your young associates and really everybody in your organization or in your firm to have mentors outside of the organization. I think you kind of need both, right? You need that internal piece and you need someone who's looking at it from the outside. And you need to create space in, if you're thinking billable hour requirements, you need to create space in that billable hour requirement to cultivate those types of relationships, to be able to go to local bar association meetings and networking meetings that they may have a luncheon so that they can build those relationships with others in the profession. And then there needs to be a genuine concern for well-being, right? So you could take these materials and look at the things we've said and maybe even craft a checklist and be like, okay. But that's not necessarily going to cut it. You have to think about your policies and your practice holistically. So maybe you have really, on paper, competitive paid time off, right? It's better than what's in the market. But your billable hour requirement or just your internal pressure of getting work done, the number of cases that the associate has means that they can't ever actually take any of their paid time off to go and relax. That's a problem, right? So you can talk about well-being all you want, but if they can't actually take that time away from work or do what they need to do to have these other opportunities, there's a disconnect between what you're saying in your policy and what actually is happening in reality. So the genuine concern comes from making sure your policies and your written kind of what you're kind of saying, this is our focus, this is what we're going to offer, and what really can happen realistically within your structure, that those match. And that's where you get that genuine focus on well-being that then creates and fosters a really positive working environment. I kind of jumped slides there. Do you have any additional feedback there, Tom? I didn't mean to jump ahead.
Oh, no, that's okay. Yeah, I guess I'd be curious your comments about the things I think about are I saw the slide, the takeaways, and this is kind of where I sort of try to boil this down for people who are involved in this conversation, and that is there's managing how do you manage stress, and that's I know different for everybody, and then there's what kind of coping mechanisms are there for people. Like it's so interesting to me because like I like to do a little bit of work on Sunday afternoons or Sunday nights because then I feel better prepared Monday morning for the week because I've gotten sort of a
Hmm.
jump start on it. Now I know
Yeah,
for others the idea of doing work on a Sunday is stress induced. And for me, it would be the opposite. If I don't do any work on Sunday,
yeah,
I feel stressed on Monday morning, like I'm not ready. So it all depends. I had an old boss years ago, and he would take 2 weeks in the summer and go away and go to this cabin where there was no television, no newspapers, no internet, nothing, and he would just read books. And he thought that was the greatest stress reliever. And I told him, if you asked me to do that, I'd come back a basket case because I need to, I like to keep up with the news. I just do on a daily basis. And I like to be connected to people. And so if you made me be a hermit for 2 weeks, I literally would go crazy. And so it's different for everybody, but I guess the idea, the two issues that come to mind for me are the best way to manage stress. And again, I know it's unique to everybody, but managing stress and coping mechanisms.
yeah.
And and with regard to coping mechanisms, I know some lawyers feel like they have to work 12 to 14 hours a day
Hmm.
to feel like they're in control. And maybe the opposite is true. But again, that's a personal preference. And so,
Yeah,
yeah, coping mechanisms and managing stress. If our attendees today can take back some thoughts on those two categories, I think
yeah,
we've accomplished something.
absolutely. So he mentioned at the beginning, so I am a yoga teacher. And so obviously the way I cope with stress and anxiety is yoga through my yoga practice, both the asana, the physical practice of yoga, as well as the other pieces of yoga. Yoga is a much broader piece and beyond just what we do on our mat. Um, but the reason I like yoga, and this is always my pitch to lawyers, is it's efficient, right? We as lawyers find like are mindful of our time and want to get things done well. And a good yoga practice incorporates some physical movement, so it helps your physical well-being and incorporates really good breath work, which you can return to in stressful situations. And it has all kinds of long-term benefits for cardiovascular health, as well as, you know, putting yourself in a way to be able to cope with stress. Um, and then for depending on your practice, there's that kind of mental, spiritual piece of yoga that can kind of, you can find the calm. So I would be much more like your friend that you referenced. It sounds glorious to go to a cabin for 2 weeks and not be able to be reached. Um, because oftentimes it takes that for us to feel like we can disconnect, because it's really hard to set those boundaries around, you know, how, and I'm one of them. How many of us have said an out of office and said you're unavailable, but you still check your email and you still respond?
Yeah.
Don't do that, because then you're ruining the boundary that you've created, right? So I think I was reading something yesterday that talked about, to be able to find balance, you have to be able to sit in quiet and listen to internally what it is that you're needing. And if you can't sit in quiet, Tom, maybe you need a little bit of yoga in your life to learn how to sit in some quiet, right? But we all struggle with that, right? So finding ways, finding practices, yoga, meditation, other pieces where you can find some stillness. And it doesn't have to be, it can be a minute in the morning can be enough to kind of slow you down and pull you back into focusing and having some clarity on what you need and what you want, right? And then from that calmer state, then you can start to find and articulate what it is that balances you. And you're right, everybody is very different. The way I structure my work and the way I work and how I work is not how everybody else is. And oftentimes just having that acknowledgement and then having that conversation within your firm can be really key, right? my most productive hours are in the morning. So if I'm constantly having team meetings in the morning, I'm losing my best billable time, right? That's when I can knock stuff out. I can get stuff drafted, right? So I structure my day where some meetings are in the afternoons when I'm kind of tired and not going to be super productive drafting something, right?
Yeah.
Thinking about and having those conversations internally is important, but taking the time to think about that for yourself and figuring out what boundaries you have to set so that you don't always have to cope, right? If we can set some boundaries on the front end and be proactive, protecting our time and protecting what we need can be helpful. But then, taking a deep breath, doing a good box breath, which our Navy SEALs use as a technique of breathing. So it's inhaling for a 4 count, pausing for 4, exhaling for 4, holding for 4. So I worked in a deep breath in this session that we said deep breaths aren't going to get us out of this mess. But finding those kinds of individual things that you need that nourish you to put you in a more peaceful, balanced state to handle the chaos that is the practice of law.
Yeah. We haven't mentioned anything really about exercise too. And that's again different for everybody. My wife and I run in the mornings, not every day, but as much as we can. And then we like to take a walk after dinner, just a short walk, around the neighborhood. For me, that's very relaxing. She and I get a chance to connect and just walk. I know that the physical therapist people like to say that you don't have to be a marathon runner or even a runner at all. Just a walk around the block can be good for you. Not only mentally, but physically, obviously.
Absolutely.
So that's something.
Absolutely. I definitely think, again, the physical activity for everybody is a little bit different, but there's so much out there and available, especially now with virtual options as well. Finding a way to move your body every day to get us out of our head, just to kind of like walk away from the computer screen or do something in a way that moves your body so you're not constantly thinking of overthinking everything that we like to do as attorneys, can be super, super beneficial.
Yeah, I think it's part of, renewing ourselves as a resource, refresh yourself. If you don't refresh or renew yourself as a resource, that's where you can run into trouble. Okay, you have another.
I have another poll,
Okay.
and I want to be mindful of our time. I know we were kind of shooting to wrap up between now and the top of the hour. Is that right, Tom?
Yeah, I think we're fine.
Okay.
Yep.
So I want to make sure y'all get your ethics credit worth, right? So this QR code will take you to another poll. We've got a few minutes. I can switch over and kind of show you as those results come in. But again, I will also post this on my LinkedIn later today. You're seeing behind the curtain today, the way that my screen is sharing, but it's being a little slow. Well, there we go.
Those are good.
We got at least one yoga. That's not me.
Yeah.
I didn't put that one in there. So we got one person on board with that.
Calendaring better, prioritize, relax, organize. Yeah, those are good.
Unplugging. I tell you what, it's really, I wrote an article earlier this year that talked about like thinking about your summer. And even if you didn't have a summer vacation, planning one day where you put your out of office and say, like, look at your calendar, plan ahead, make sure that there's no critical deadlines or anything. But one whole day, I promise, one whole day, you can walk away from the office and not check your email and go be outside or go do whatever it is that makes you happy. Maybe it is Netflixing. I love a good, marathon, but finding one day to just unplug and walk away.
Courtney, I would be remiss if I didn't mention that I noticed somebody wrote "pay my premium."
Thank you.
Yes, yes. No, that would be nice, but no pressure, no
Well,
pressure.
good. Well, hopefully that means that we've done our duty in making it clear the value that you all offer, being a WILMIC insured, for sure. So I want to open up for any other questions that may come in. And again, I will post those word clouds either later today or maybe first of next week, on my LinkedIn, and I'll tag WILMIC, so you all can see those
Okay.
as well.
Yeah, I'll just mention one other thing. And as you said, audience members, feel free to shoot questions on the Q&A now if you have any. The idea of disconnecting, I think many lawyers feel a hesitancy to disconnect even for a short time because of again, I go back to the client pressures, and the client demands. They're afraid of missing a client request or a client question or some demand from a client, or something involving cases they're working on. And that this idea of being afraid to disconnect, I think, is real. And so I don't know the answer to that, but the idea of disconnecting is nice. But I know some lawyers just feel they have to be. And again, technology has done this to us. We're permanently connected all the time, and there's no break for many people.
Right. And one response to that is the rules do allow under the communication rule. I can't swear to it in WILMIC, but I'm pretty sure yours is the same, or in Wisconsin, but I'm pretty sure yours is the same, that it talks about responding within a reasonable amount of time, right? So, if you are going to be away and you're not going to respond, if you put that out of office on, it puts the client on notice that you're not seeing it, not responding. I know you all probably, we always had lots of solo practitioners. You all probably do too, but there probably is, in most cases, at least some sort of staff person also available to check that email so that you can disconnect that. And that can be part of their training, is learning when, oh wait, this really is an emergency. I need to call them and say, hey, I know you're disconnected, but you're going to have to look at an email, right? Putting those processes in place, and that's part of the proactiveness is figuring out a way so that you can connect. I think if we're looking at a burnout problem in the profession, and this is the hang up, then what can we do to put systems in place that we can feel comfortable taking a step back, because you have to, or you are going to stay in that burnout state.
Yeah, we do have one comment from an attendee in the audience. They didn't get the QR code in time to load, but they chimed in and said they're going to look to exercise more and reject cases that they should avoid. I think those are two really good ideas.
Yep.
I always say saying no to a client, saying no, N-O period, is a complete sentence. Don't be afraid to use it.
Yes. And if you don't like them that first meeting, it's not going to get any better. That's the best you'll ever like them.
Exactly.
Looks like maybe another one.
They don't like the use of the word absolutely. So, for whatever that. Okay.
Gotcha.
Yeah, all good. Well, Courtney, thank you so much for everything you've given us today. Great insight, great information. Matt, I'll throw it over to you. And again, thanks for letting Courtney and I spend an hour and 15 minutes with our audience today.
Thank you, guys. I appreciate it.
Absolutely. You were both terrific. Thank you so much. Good insights, and hopefully we all become better people and better lawyers. That should do it. But thank you to the attendees. Thank you very much for coming. We are happy to do this, and we will have one more 3-hour program, and do keep an eye on your email inboxes for a free CLE Friday session next month. So with that, again, a big thank you to Tom and to Courtney and to Bill and Brian for the program this morning. And I'd be remiss if I didn't say thank you to Stephanie Williams, who was instrumental in putting this together and bringing this virtual program to you all and making it really, really easy on the presenters. So with that, have a great Labor Day weekend. If you're traveling, travel safely, and we look forward to talking with you again soon. Take care.
Thank you all.